Matters, your legal aid clinic showcasing live on TV. And particularly on this day, we are looking on matters of what happens when technology collides with your rights. What is the remedy? What is there to do? And to move into this topic, I am very happy to be with Dr. Nelson Otieno, an advocate of the High Court and a lecturer within the premier Kenyatta University. We are going to talk on matters of technology and human rights, because it is key for you to be one of us with where your rights come in, and also to know to what level technology can also come in. So, Dr. welcome to Law Matters. Feel at home.
Thank you so much. I appreciate your warm welcome and great introduction. Nice to be here. I know that the last time we could not get an opportunity to be here in person. I'm really glad that this is possible. Looking forward to the discussion and also warmly welcoming our audience today.
Yes. And technology was able to assist us on that end, and we were able to have the show in one way or another.
Yes.
However, the topic that we are looking at today, resilience. The first thing would be one to understand what is resilience, and particularly what is the future of resilience in Kenya, particularly looking at our digital spaces from a human rights landscape point of view. Where are we in matters of building up this resilience? Are we at the beginning? Have we even thought about it, or are we still in limbo?
Great. I think this is a very interesting question. I will just tackle the two limbs. One is what is resilience, especially in the context of the discussion today, and where we are. For resilience, I think that the discussion about protection of rights is a discussion that pits what is in constant struggle. Since the recognition of rights in 1945, the Declaration on Human Rights, the adoption of various covenants on protection of rights, up to now, human rights struggles are still ongoing. And that is even much more accelerated by the fact that technology is even eroding on a lot of rights. So resilience is the rights themselves fighting back to try to reclaim what was the traditional space of rights protection that is being eroded by the rollout and implementation of technology. When you ask where we are, I think this is a discussion we are going to maybe see facets of it coming out today, but my view is that we already have a framework. If the Kenyans in 2010 imagined that we have a constitution that is going to be the frame on how we need to protect rights, both in offline and online, then we already have a framework. And where we are going now depends on how we are going to play within that framework to ensure there's innovation as well as protection of rights.
Interesting that you've brought out the aspect of the constitution. And if my memory serves me, the constitution came in play before ChatGPT, which moves me to look at the law perhaps in matters of trying to catch up with the trends that are around. When, from your now professional legal standpoint, is our constitution up to beat with managing the situations that we are in right now, noting that technological advances are on a consistent progressive mode?
Great. I think this is some good point of reflection to make. So you say constitutions came before ChatGPT. This is really interesting. Perhaps it's a point for me to reflect on a bit. If you look at constitution and constitution making, it's usually a very long process. So up to 2010, Kenya having to do away with this 1963 version of the Constitution, and that shows you the Constitution had been there for close to slightly over 5 decades. In 5 decades, a lot had happened, and if you look at the way constitutions are made, there are ways to amend the Constitution. There are ways to try to, either overhaul the whole constitution, but most importantly is on how to interpret the constitution. So under Article 259 of our constitution, there is a provision on that the constitution itself just provides the basic frame. It also enables Parliament to pass certain laws. That's why since 2010, we have had laws like the data protection law being passed to give life to the constitutional protection on privacy, especially that guides the whole technology space. So I see that the whole architecture of the Constitution was for the present, but also envisaging the future. That should there be problems, then the Parliament will have to pass certain laws, and that's why we have Cybercrime Law of 2018, the Data Protection Law of 2019. Again, as you are aware, there's a current bill on that is on regulation of artificial intelligence, among as many others. So it is a living law, and that living and evolving nature is what makes it relevant for regulation of technology that might have come way after 2010.
And when you're talking about matters of artificial intelligence and the progression that we are seeing, for lack of a better word, Africa as a continent is seemingly playing catch after the developments that are coming up. Our presence in the room is something to really ponder about. So how do we come up with legislation that is able to, one, manage innovation that is not within our jurisdiction? How are we able to merge that? And probably, have we been able to make milestones towards that?
Well, this is also very, very good point. I believe that the question goes to who actually makes the law. Because it's like, how do we make the law? Maybe assume that we all sit somewhere. We also have legislators. So for me, the point is the legislators have to be conscious about the African approach to regulation of artificial intelligence. What do Africans actually want? And on the point that you raise, it also goes to the fact that there can be nothing for Africans without Africans, because if they're not on the table, then they're obviously being eaten, so to speak. So I believe that consciousness is really key, and it has to be very deliberate consciousness, because technology is a space that is dominated by big technology companies that are also running a lot of other things, and so it is possible for them to influence legislators, through lobbyists to try to force certain standards which might not serve the interest of the local mwananchi, say living in Kilifi or Turkana. So someone who is a member of parliament who is debating the bill, the AI bill, has to be really conscious of what is the position of Africa, what's the position of Kenya in terms of advancing the innovation as well as advancing the protection of rights. One of these fine weeks, I was having a class where I was teaching biotechnology law, and we were imagining with the class, how comes we have not imagined a framework for ensuring we can protect the whole biotechnology around Mursik, for instance. It is easier to talk about GMO because that is being promoted by some other interest, big company interest across the world. So consciousness is really key from that perspective. Whether we have gotten there, I believe that from the African regional point of view, a lot has happened. At the AU level, a lot of laws have come, either through model laws, continental AI strategy or digital transformation networks, the AU Vision 2063, which is also complemented by other visions across the sub-regional economic communities like East African Community, but there is a bit of lack of goodwill in terms of adopting that into national frameworks like we have. So this a lot of states still looking up to other countries like the European Union or the US for standards. So maybe that is one of the areas that we might have to really be keen on if we really want to achieve a very African-centered approach to regulating artificial intelligence.
Let me poke your mind.
Yeah.
The aspect of an African situation brings the thoughts of Ubuntu to my head. And Africa, we kind of have a community approach to life. But if we are to look at the progressions, particularly on technology, they tend to have a capitalistic motion. So since we cannot also sit back and be left by the trends and maybe be left somewhere behind history, if you were to assess this with your own opinion, how do you think we can be able to, one, move towards adopting the good aspects of technology because they are there, while at the same time holding ourselves culturally true in our own Ubuntu motion. How can we do that?
Great. I think the point that you have raised, and even before I go into these two aspects that you need, is that we are not going to wait for another country or another region to come up with standards that implement an African standard, unless African countries come up with that. There have been discussions around the Ubuntu approach to technology governance generally, and also Ubuntu approach to AI governance. Now, more specifically, I know researchers who have worked on this and conferences on how do we actually realize this. I remember one of the discussions we had in the first data protection conference in Africa, the first global data protection conference in Accra. One of the discussions we were having is how to achieve this African approach. Now, I will say, how do we actually get there? Now, the first challenge is, how do you get there if that first conference you're actually attending is funded by a European organization? It is not going to be possible because whoever pays the piper calls the tune. So if the outcome of the conference is already predetermined, all these discussions are just to tick the box. If we really want to move the discussion forward, we have to also pump resources in research and also as well as building capacity. Now, that will help us to really make advancements. But I also believe that as we try to do that, nothing is lost. If you look at the African Charter on Human and People's Rights, which is a very unique charter because it provides for people's rights. It says people's rights. It actually recognizes that rights can be enjoyed as peoples instead of individuals. So much as we have had challenges with the definition of a data subject saying is an individual, we have also had instances where people in their capacity as peoples can go and claim that their rights have been infringed. Let me give you an example. The Nubian community living in Kenya who challenged the implementation of Huduma number. They were a community, but through the Nubian Rights Forum, which is a collective organization, they were able to activate for their rights, both their right to that's the freedom of association, but again, pivoting from what we already have in the African Charter. So yes, we have things to do to advance, but from the progress we are seeing from the activity by the CSOs, as well as how deliberate they are with using the available resources to achieve that collective protection in the age of AI, it's already very impressive, and I think the future should be bright.
Well, really, going to the future requires you to have also a gauge on the past, so that you're able to get the direction and know, okay, we are now progressing in this particular direction. Just digging back to the Constitution, now before we had the 2010 Constitution, the matters of human rights seemed more like the protector of these rights is the state. But when you come to the 2010 Constitution, now it becomes something that human rights are an inherent right to human beings. The responsibility seems to have shifted. Now it is like it is something that is mine and mine. How does this play within the digital shift that we are in when this is an inherent right to me? And at this moment, you're talking about how we are mixing up and having that blend between technology and human rights. We are trying to bridge, okay, how can we ensure that both move together without one depressing the other?
Yes, I think that it's really nice to reflect on what the Constitution really thinks about, really presents as what Kenyans thought when this document was being passed. Maybe the first issue that comes to mind is Article 10 of the Constitution, because Article 10 provides what's called the national values and principles, which binds all persons when they implement the Constitution. Now, that's very important because a long time ago, the obligation to respect human rights, respect for human rights is one of those values and principles. So that's very key. But long time ago, and traditionally, the protection of rights was only a preserve of the state. So it is only the state that was obligated to protect and implement rights. So that it means if you were under a dictatorial regime, then there were constant erosions on the content of the rights you enjoyed. But right now, we have that obligation placed on every person. And a person defined under Article 260 of the Constitution includes associations, businesses. So we have a constitution which binds businesses, even the big technology companies. Now, this is very important. We've had instances where big technology companies are saying, oh no, we can't be sued in Kenya, yeah, because we don't have a place of business within the republic, but the activists are telling them, wait, we are under a new constitutional dispensation. Now, I feel that alone is really important because we have sustainable development also as a key value. So it means that all forms of development, as we are talking about economic development, it has to go along with the social development of the peoples as well. So there's a balance that is already introduced. For me, Article 10 is also really key. And if you also go to the Constitution, the Chapter 4, where we have the Bill of Rights, Article 31, for instance, was not in the previous bill, the previous constitution. So having the right to privacy itself and now being put as an inherent right that every person has now really, really raises the bar. And therefore, there's no surprise to me that a lot of government initiatives still are being challenged, in some cases successfully, for having failed the master of Article 10, Article 31 on the right to privacy, amongst many other rights protected under the Constitution. Yeah.
And when you extrapolate, and now you're talking about matters of privacy, perhaps from a base level, what is data protection all about?
Yes, I don't know what you mean by base level.
Base level, as in I'm imagining my humble mother, who went up to somewhere in primary school, and she's hearing about data protection. Recently got a smartphone. She's now enjoying the likes of many social handles that can be able to just move from here and the other. And now this aspect of data protection is being floated about. If I wanted her to understand within this conversation, how would you break it down into manageable pieces?
Great. I will attempt this, and I hope that it's a successful attempt after all. Data is information about, let's use the example of your mom, if that works.
It works.
So, Mom A, data is all information that is relates or concerns her. It could be her name, ID number, NSSF, SHA, all this employment number, all this information that they have. And it also goes beyond that. It's also about the voice, their likeness, their image, all that can be represented in a photograph. And that also is then connected into the digital life. If it is presented in a digital form, if someone is able to know where they went to school, what was the performance, all this information about Mother A, is that information is her power. And the law recognizes that she should have control over that information. And when she shares it with someone else, that she should have control on how the person with whom the information is shared handles that information. Because without that protection, then Mother A is exposed. She can be unnecessarily surveilled. Someone can use that information to blackmail her or to perform an action which will otherwise be fraudulent and might cause her to lose property, for instance. That is why the law strikes a balance that for information that relates to her personal life, it is about family life, someone should not ask her unless it is absolutely necessary. For information that are about her health, property, children, relations like mother, their gender, all these are deemed as very sensitive information, including religious beliefs, that they can only be given or handled in a particular manner. For other information which are not sensitive, they are also overly protected. So Mother A will be is given rights under the law. The person to whom she gives that information is also bound by obligations under the law to ensure that that overall protection is assured. And should that person with whom the data is shared decide to transfer it to another country, the law still comes in to say what standards need to be placed to ensure that even that transfer is also in accordance with the safeguards required under the law.
Wonderful. Daktari, as my mom now ponders on whatever you've said, I will come back to ask you. There are very many applications that she blends with. Some ask for, can we, and she gives yes. So we're going to go for a short break. But when we come back, I want to know the extent of consent, one, that I can give about my data that is, one, legally correct, and what would be one, or for lack of a better word, being coerced to be able to release this data, which now would, I think, fall into an illegal situation. We're going to come back in a break. This is Law Matters, your legal aid clinic showcasing live on TV, live on KUTV. Of course, we do invite you to come in and also share your questions through our social media handles at KUTV_Kenya on the X platform, and of course KUTV Kenya across all other social media platforms. Tell a friend, KUTV Kenya is streaming live, and Law Matters is here just for you. So share your questions, whether on Facebook, on this live stream on YouTube, and we'll be able to also break them down, particularly on this topic, which is very pertinent to us, on matters of, one, human rights and technology. Where do you fall? What do you not know? Share it and we'll be able to break it down. Be sure to be there. In a moment, we'll be taking a break and we'll be back with Dr. Harry.
Msana lugha. Lugha ni zaidi ya maneno. Ndio maana sisi Waswahili kila siku tunaitumia kazini, mitaani, kwenye mapenzi na katika jamii. Jiunge nami Padironga kila Jumapili katika Mawimbi ya Lugha, tukichambua Kiswahili kwa undani, maana yake, mabadiliko yake na nafasi yake katika maisha yetu. Kutoka utambulisho, mapenzi hadi mustakabali wa lugha yetu. Mawimbi ya Lugha kila Jumapili, usikose saa 2.
Ninakukaribisha rasmi kwenye Mitindo ya Kipwani, kipindi kinachokuza utamaduni wa Kipwani, nikikuletea mazungumzo ya moja kwa moja na wataalamu, vyakula vilivyopikwa na kukorombezwa, viungo mwake vya Kipwani, ngoma zetu za asilia za Kimijikenda, bila kusahau tarabu na chakata. Yaani wanawake Uswahilini watakuwa wakinengua na kuzungusha viuno kama panga boy za trekta ndani ya Mitindo ya Kipwani KUTV, ukiletewa moja kwa moja kutoka Salama Bling Beach Resort kila Jumamosi saa 10 jioni na Jumapili saa 4 usiku, ukiwa nami mtamu wako zaidi ya asali. Mimi naitwa Waridi Tamu. Mpenzi mtazamaji, usipitwe na matamu.
Welcome back to Law Matters, where today we are looking on matters of technology and human rights, and also imagining a resilient future, particularly for the Republic of Kenya, which has been one that has been on the move to embrace technology in each and every dimension. I mean, there's nothing that we are not embracing. New trends, we are here. And of course, we even have that infamous name across the globe. Kenyans on Twitter are well known, and other platforms. But particularly now we are trying to look at matters of human rights. How does that connect in? And before we went for a break, we were in a conversation and steeply in it, and I'll engage you to go back to it in case you are viewing this later on with Dr. Nelson Otieno. And particularly, I was with you, Daktari, on matters of how much data about myself can I release on a legal standpoint, and does my consent mean that all the data that I've submitted is in a legal capacity with whoever I share it with out of my consent? Is there anything like too much data shared?
Well, that reminds me of a conversation I saw going on, and I think from the Ireland Commission, Data Protection Commission in Ireland, they call it share renting. It is the act by parents to continue sharing information about their children online. So they were calling it share renting. Maybe that just stick my mind, but let me get back to the point that you raised. The aspect of data protection is about control. And the control is on the data subject. In the example, our example is the mother A. So she's the person who controls that information, because that information belongs to her. So she's the data subject. She can release all that she wants. That is why all people who handle data are allowed to collect data that has been made public by the data subject. So if you see that the data subject, if it has not been made public, then now there are standards. That's why one aspect of data protection is like security. It starts with you. So it has to be very conscious about what you make public, because if it has been made public, then a data controller or a data processor, which is just names for those who handle data in different capacity. For example, when you go to the hospital, you give them the information about you, if you go to church, or if you go to a school, or if you go to whichever institution or company. All this, they can use this data which has been made public. So you can give as much data as you want because you are in control. But part of being in control is also that that data has to be collected. If you haven't made it public, it has to be collected only under certain circumstances. And that is where consent comes in. Is consent the only way through which the hospital, the church, the school, or your employer can collect your information and do other things with it, which is usually called data processing? So maybe they collect it, store it, analyze it? No. Consent is just one amongst many others. So they can collect it either based on your consent, and you said we are going to talk about consent, I'll just leave it at that. But besides that, they can say that we are collecting it because we are under a lawful obligation to do so. So assume that Mother A is taking up an employment position, and the employer wants NSSF. The employer wants police clearance, or the employer wants a CRB certificate. They'll say, because we are compelled by the law, so that you give us this information. In some other cases, it's about to protect the vital interest. Someone is sick. There's no information that can be. Someone can go and find information about their next of kin, for instance, so that they can call, so that they can make steps. So there are also several reasons besides consent. If the data is required to enter into an employment contract or to conclude it, it is possible that someone can use that basis. If it is to perform a public function or to comply with a lawful, a lawful obligation under the law, it is possible. So yes, consent is good. It has to meet certain standards which we'll speak about, but it's not the only one. But the ultimate pivot is on the control.
So if I was to ask, if I am maybe going for an essential service, maybe I'm in hospital, as we have talked about, and they require my biometric, and I am not in a position, maybe I'm not even conscious, and they do take this information from me, now my biometrics, is that assumed like a matter that would allow them to do that? Is it, where does consent begin and end?
Okay, this is I think it is the elephant in the room. And I also understand that the elephant in the room was just a rat which became too big. It wasn't like an elephant when it got into the room. I think for this point, the consent itself, the rules on consent, which the Office of the Data Protection Commissioner has developed guidelines called it's called the ODPC Consent Guidance Note. It's a guidance note on consent. It requires that consent has to be granular. So to explain this, it means if you give your biometrics for the purposes of registration, that biometrics should not be used for any other purpose than for the reason that you gave it. Because we've had instances where someone gives their information to an M-Pesa kiosk, and that information is then used for purposes other than for processing the money transaction for which it was. So where does it start? The person collecting that data has to have a lawful purpose for which they are collecting the information. And then the second one, they have to decide that collecting it directly from you is the best option, because there are also other options of collecting it from other agencies, or maybe if it has been made public. So that is the second point. The third point is, now what need they do to ensure that the consent is valid? Under the law, the Data Protection Act, Section 2 and Section 32, there are provisions what is actually consent. So consent has to be unambiguous. It has to be expressed. So by someone being silent, by someone saying, yeah, that does not mean consent. So there has to be an option for yes or no. And there has to be an express signification that a person says yes. In this case, by putting the thumbprint on the identifier, the biometric identifier will signify that a person has consented. But that consent does not go all the way. It has to be only for that purpose for which it was collected, and there has to be a consent form explaining to the data subject, why are we collecting your data? For what purpose? With whom will we share it? What measures have we put in place to ensure that it is protected? What are your rights? Who should you contact if you have problems? These are the standards. And if there is any operation outside that framework, then there's a violation of the law. Yes.
And if to look at the state that we are in currently, I think in matters of human rights abuse, it got updated within the 2024 finance bill. We saw an update of human rights violations. They still came on to the year 2025. But one thing that was standing out was one, on the claims, and rather some are yet to be justified on matters of abduction, is that one, I was pinpointed by a certain provider, and they're the ones who were able to pinpoint where I was. And because of this, when my position was exposed, which I believe, I stand to be corrected, is my data, I was taken through a process that really infringed on my human rights. I would beg to ask, one, the contest was whether this was right, which indeed it wasn't. But right now we've seen an update within the Cyber Crimes Act. I don't know if we still work within the same parameters, or is there anything that maybe has been annulled or updated within that particular guideline?
Yes, and I think for this question, it actually speaks to how technology can accelerate or enhance human rights violations. So, okay, we want, because, taking someone, abduction is a violation of several rights that are protected under the Constitution. So then in this case, where the technology is used to identify the precise location, is a technology, it is a technology-enabled violation. So it's it helps with mediating that. And I think this has to do with the powers that the police have to in terms of the investigation and also ensuring security, but also on the other side, it also has a bearing on how to ensure that the right to privacy is really protected. And as you say, the one of the contentions that has been in Kenya since 2018, when we had the Cybercrime, Computer Misuse and Cybercrime Act 2018. Once it was big operationalized and became an act of parliament, the Bloggers Association of Kenya took a petition to court in 2018. Challenging constitutionality of several sections of the law. I did my master's thesis on that very law, and one of the issues I was also looking was that decision by the petition by BAKE, the Bloggers Association. It had not been determined then. Subsequently, there has been a lot of developments, because then the court declared that there was nothing unconstitutional about it, and BAKE appealed to the Court of Appeal, and very recently, in the course of this year, the court had made very, very good analysis why provisions under Section 22 of that Act were unconstitutional, because they were too broad and they could not fit within the standard of limitation of rights provided for under Article 24 of the Constitution. So yes, we are seeing this contention between national security, which we must admit is also a key consideration, because everyone has a right to security, and the government has to do something. And also, where does that then leave the right to privacy? I believe that the Court of Appeal decision is a major win, and it's also a major guidance to the lawmakers and also the policymakers on where do we draw the line between the use of technology, especially mobile phone data. I think that for some conversations I usually have, I say, okay, then I talk to my DCI friends. Like most people have their DCI friends who can help them crack or have access to other phones, and this is happening within the country. Other than those cases which we must admit are wrong, there are cases where they need to use the information to, get to either as part of forensic investigation into cases. But I believe that development that we had, especially coming after the contention we had the cybercrime law amendments for this year, was a major win, because it was a guidance on the fact that if you prescribe a law which can be used especially by the government to intimidate, to harass, and to threaten, especially persons who are not of the same political persuasion, then it is possible that it will be bundled together and seen to be unnecessarily or unjustifiably limiting the rights protected under the Bill of Rights, including the Article 31 on the right to privacy.
And when you're talking about this motion, and particularly even in bringing that question, I'm thinking about activism. Because one thing that usually allows a democracy to thrive is the fact that you can be able to actually contest these matters in being an activist. I'm looking in the years past, we had activists who had a lot of political support, also support from generally various aspects. But right now, digital trends means also the trend of activism has also evolved. We are now seeing activists online. They are presenting their thoughts and also moving their expressions on these platforms. But it's also coming with some, I don't know how to put it, but kickback from the various places where they move this aggression towards. I don't know, in your opinion, is it about time we also look at online activists on the same parameters that we are looking at the likes of the late Ngugi wa Thiong'o with his literary works? Is it about that time we look at them with a different eye?
I want to agree with you that it is time we look at them in that way. Why would I say so? That activism on rights is a very unique one, because if you look at the declaration on internet freedoms in Africa, the AU declaration, it declares that the rights that are protected offline should be protected online. So if you are an activist offline, it means that if we are protecting rights online, you should have a similar status as the activist online. I think also from the effect, let alone now the scope, the effect that the online activists are having. I'm one person who believes that, activism is not about violence. It's just about believing in something and expressing something which will make someone believe that this is actually your belief. That makes you ready to an activist. I actually consider myself an activist because I teach, I practice, so it also means that I have certain ways of expressing what my persuasions are. I believe that the chance that we are in, especially around the digital rights protection, and the spaces where we have the government have moved online. There are a lot of social media handles that are being, created for government offices. They are also engaging with the public there. This is actually a very, very good space. 2024 showed us a good deal of how online activism could actually play a good role, but one thing that I will add, that it has to be coordinated. It has to be coordinated because we've seen them really rise and then they dissipate because someone could say it's an online activism for pay, as you say, maybe there's a kickback or something, but I think that it has to be coordinated. And for me, the best activism, and this is what I actually recommended when I was doing my doctoral research, is activism which is blended online and physical. And this activism also, because I've also seen some trends that activists are also run over by elitism. And for me, that is also a big challenge, because when you see activism either being eroded by political interference like we've seen, or by elitists, so that activism is so elitist and then it leaves the people behind, that's a problem. So for me, the way forward is have them all together, let them be blended, and let them not leave the people behind. With that, we have a very big promise for digital activism in Kenya.
Move to with the people and have that inclusion. Yeah. We are due our second break within Law Matters, and I wish I could expand this, but probably we're going to have another moment. But as I come back, now we're going to go to the judicial spaces, because we are having matters of online courts and the like, and a lot of adoption of technology, particularly within our judicial circles. So we're going to be delving on that alongside other topics. And of course, I do call on you, wherever you are, to be able to share your questions on social media handles at KUTV_Kenya on the X platform, and KUTV Kenya across all other social media platforms. We'll be breaking them down as you walk into that face of Law Matters, your legal aid clinic, showcasing live on TV, KUTV.
My name is Jakub Petri. I'm Associate Professor in the Institute of Philosophy of Jagiellonian University in Krakow, Poland. And I'm the main coordinator of the CAFE project, which is being here hosted by Kenyatta University.
My name is Ewa Hudoba. I am a project manager in this consortium. Keep watching cutting edge research at Kenyatta University Television.
Kila safari huanza kwa hatua moja. Bila shaka, dira ya Boresha Kilimo sasa imepata sura mpya. Boresha Kilimo si kipindi tu, bali ni darasa la vitendo kwa wakulima. Lengo kuu, mavuno bora na tija kwa jamii.
Na ukikaa nasi basi utaboresha kilimo.
Hapa tutakupakulia maarifa takotia ladha ya kisukari kwenye mazao yako, tukitofautisha punje na mpunga.
Kwani kilimo ndicho huboresha maisha.
Kuanzia maandalizi ya shamba, mbinu za teknolojia ya kisasa hadi sokoni, usikose kutazama Boresha Kilimo.
Ukitaka kujua haya usipime kipimo.
Ungana nami na hodha wako Akida Kasim kila siku ya Jumamosi saa 6:30 mchana na Jumanne asubuhi, nikikuletea shajara kamili za wakulima na suluhisho mashinani.
Kilimo ni nguzo kubwa kwa ujenzi wa taifa, kwani kilimo ndicho huboresha kuboresha maisha.
Kumbuka, ukipanda pantosha utavuna pankwisha.
Choose your legal aid clinic showcasing live on TV. And particularly today, we are talking on matters of technology and human rights. Now, if I am to refer back under Article 33, let me move from the top now. And Article 31 guarantees that every person has the right to privacy. Article 33 of the Kenyan Constitution, rights to freedom of expression. Under Article 35, the right to information. These are the cornerstones of a free and just society. But within this digital age, we are seeing a lot of progression that is not only being changed by the law itself, but also by the fact that technology is also moving at a pace that we really need to catch up with. And today we were having this conversation with Dr. Nelson Otieno, a lecturer within the Premier Kenyatta University and also an advocate of the High Court. And particularly because we're talking about the court, Bakari, we are going straight to the court. We have seen the judiciary adopting various technological aspects, e-filing. We are seeing cases being filed, and also we are seeing proceedings happening on a digital perspective. And my curiosity comes to one, we do have a proper penetration of technology within Kenya. Around 67% of Kenyans are actually connected to mobile telecommunications. But still there is a certain, if it's 67, then we have another number that is not included with this. And I don't know, in the motion of the judiciary moving to adopt the technological trends, because it has to be inclusive of all, what happens to that number? Is it that by seeking to extend justice, particularly through this means, some may actually lose out on justice?
Yeah, this is a big point to reflect on, and it's also really key on how technology intersects with rights. I agree with you that recent statistics from the Communication Authority of Kenya already show that there's a rise in the trends for smartphone penetration across the country. Of course, the rural populations are quite disadvantaged. It can be quite representative of the urban population. I think that from the progress made, the inclusivity has been with access. And maybe the access is also being enjoyed by advocates who are able to attend multiple matters. Maybe in a day, we were actually speaking with some colleagues that these days it's easier to actually have like 5 matters, and you're doing one in Wajir, the other in Mombasa, and that. And like the other days, you could just spend like a whole 5 hours in court. So it's good from a practice point of view. And also for those with smartphones, that means that access to justice is easy. But I think the point that you raise is also very cardinal, because under Article 27, there's a guarantee of equality and non-discrimination. And everyone has a right to fair trial under Article 50, and also under Article 48, they have a right to access to justice. And that means that there should not be any unreasonable impediment. I feel that this is one of the things that the judiciary has to take a keen interest in, because I've also had engaged with a population, part of the population, who are not really aware of how the system works, or are not able to prompt the system well, so that it's able to, they're able to get the updates. And for me, once even the advocates struggle with the system itself, how prompt it's possible to get the judgments once they have been read, how they can be promptly uploaded on the e-filing, then you can imagine the struggles of Mama Onyango in the deep, or in Kondele, Kisumu, or Mama Aisha in Kilifi. So I think that this is something that we have to confront. I know that the judiciary has done a policy position on that by adopting a policy on technology in the justice sector just this year, and I know that this policy, we should be able to see more progress. But this is something that we have to really, really confront, because justice is not just for the urban population. And justice is much more than what the law says. It is about, do everyone go and feel that they actually found what was just? And it doesn't matter. The judge can be just, the lawyer is just, but the system is not just.
And now, since we were there, my mind has now rallied back to our previous conversation on matters of data privacy. So imagining you're having a virtual court session and I am there. You've actually noted out to me that my data is one, my name, and also me, myself, my voice. This is my data. How does the judiciary ensure, one, maybe I am not comfortable to be on this platform, I'm not comfortable with my data here. Now there comes the matters of consent. How does it address that situation so that I do not feel like my rights are being infringed by me, being compelled to be within this session in this way?
Okay. Maybe perhaps a huge Herculean task to speak on behalf of the judiciary, but maybe I could share some experiences that I've had. So, from the courtroom, there has been a case where someone took the Law Africa Publishing, which usually does the publishing of once you go to Law Africa, then Kenya law, the court cases are being published there from time to time. So a person had gone and said that the continual presence of his name in the decided case was a violation of the right. And the court declared that that was not so because of the nature of cases. Cases are being decided so that people can learn from them, and that reporting, especially for High Court, which is a court of record onwards, it's very important. Now, court proceedings are public proceedings. In fact, that virtual attendance is only a simulation of what would otherwise have happened in public. And there are special cases, especially for children or for very vulnerable witnesses, where they can maybe be protected, and there is a whole framework for protection, for witness protection in Kenya. But in cases where you attend, it is still within the law for the judge to ask you to show up your face. And that is also has some side to it, because the legal fraternity has been dealing with cases about rogue advocates, or maybe non-advocates who are practicing, and so perhaps someone will say, may we see the face to see whether that's actually the same person. So it also serves a purpose. Of course, there could also be a potential abuse, because I've seen sometimes people go online and post what was happening virtually, and people attending court from their bedrooms and stuff. But I think the whole idea is it should be a public, and by insisting that one shows up their face, that should only be for good reason from a legal practice standpoint, and it should not necessarily be a violation of a data protection law as it is. Maybe there could be additional factors that will make it so.
But I'm curious, on your experience, I'm imagining when you are cross-examining a witness, and there are some nuances that I may be able to bring forth when it's on a live, and you're actually able to press my buttons, and I'm able to actually either break and bring out whatever you were looking for, because some of us are consumers of suits and stuff on TV, and we imagine this was supposed to be happening this way. So when you're having it on the virtual aspect, does it not lower the efficacy maybe of cross-examining a witness than if it was actually the witness was actually there present on a physical capacity?
Okay, allow me to not reframe the question, but to deem that you are asking a question which is very, very overarching, in the sense that, can technology actually replace the lawyers, or that very personal aspect of legal advocacy? Perhaps, because it could be that cross-examination, or perhaps it could just be submissions. One could say, what if I create an avatar and feed in my submissions and let the avatar be projected in court and represent me. Especially one will say, but that is so nice. Then we have issues about access to justice. Then everyone doesn't need a lawyer or something like that. So I think that has been the overarching question. In one of the trainings we were having for advocates within Nairobi on the use of AI in the legal profession, with our colleague advocates, we were advising on trends, and one of the trends was a person who had brought an avatar to represent them, and then the avatar comes and say, hey, I'm so and so, I'm the advocate, and the court, the judges said, hey, stop, our rules don't allow that. So why was I mentioning all this? Is because you pivot to first the rules and what the courts are saying. Now, the courts are saying that there are aspects of legal advocacy that are so hard to leave to technology. Because, you know, other than the evidence brought to court, one of the main things that the judges look at to decide cases, especially in the first trial, is the demeanor of the witness. And that demeanor is brought out as they give their evidence in chief, as they are cross-examined. And so that is one of the gaps that is usually then missed by judges. The law as we have now, under the civil procedure rules, allow courts to have, you know, transcripts of proceedings. And the question is then, the fact that it is silent on whether it is possible to use these avatars and that, is it permissive? Because sometimes you say what the law is silent on is permitted, or is it the fact that it is silent, then we should say it is prohibited? I agree that there are human aspects of legal advocacy, as you've said with that example, and among as many others which the technology cannot replace. I recently read an article on the experience of the use of AI tools within the courtroom in the US, and I agree with what the writer was saying. We should see these tools are capable of augmenting the work, because in that case, the AI tool had assisted the client in drafting the case, in filing the case, in making the case proceed all the way to trial. But at the trial, now the client engaged a law firm, because at that point it was not possible to do re-exam, cross-exam, and re-exam all together with the technology. So I think it's in Kenya, we were doing an article recently about the use of AI, and we realized that from the courtroom jurisprudence we are seeing, courts are rather slightly inconsistent, but very conservative. So maybe we pass that stage so that the courts are able to allow that legroom, and then we can have those very technical discussions about the scope when we reach there.
Dr. Nelson,
yes,
we are pressed for time. And I really do appreciate, because this has been an informative bit for me, and I do hope it has also been for you there at home. And if I was allowed 1 minute or maybe even 30 seconds, I'd ask you where you would advise the youth to look at, or rather to focus on matters of technology and human rights. Where is that aspect in one line as you wrap it up? Do you believe they should actually pay more attention to right now?
I would say that because they intersect, it is impossible to be a human rights advocate or lawyer if you don't want to look at the technology side, and vice versa. So I will say the point of intersection is understanding the fundamentals of both. Yes.
Well, that's all we had for you right here on Law Matters. Time is of the essence, but still, this information is with you. And of course, you can go to share your questions, and I'm sure I can be able to engage Wakil in one way or another, and also give you a valid response, and one that is legally guided. This is Law Matters, your legal aid clinic, showcasing live on TV, of course, within the Kenyatta University Parklands campus, the place where the law is everything. And of course, it's now moving towards giving you a broken down motion that you're able to actually capture and understand it in bits that are manageable to everyone across Kenya. And also, in case you're interested, of course, in the law practice within the Kenyan Republic. My name is Emmanuel Kutosi, and until next time, I will say goodbye, and keep yourself informed, and also refer back, because this is a class in session and a class for life.